The time is now 1:30. It is June 18th, and the regular meeting of the City Planning and Zoning Board will come to order. And today we have preliminary matters, agenda, and deletions or additions from the board members or staff.
Staff has none, Mr. Chairman.
Board members?
None.
Seeing none, we'll move on to public comment. Now's the time for public comment. If you would like to comment about anything in general, you have the opportunity to come forward. If there's something else on the agenda that you're waiting for, which is only one item today that is planned, okay, you can come up at that time also, or you can actually come up at both times if you'd want. So right now, this is open for general comment. If you'd like to come forward for public comment, please do so. Seeing nobody coming forward, we'll close public comment. Today we have a public hearing, and it is a petition of William J. Stewart on behalf of Christian and Dawn Cyrus. Did I pronounce that correctly? For a variance from the 15-foot side property line setback for a finger pier and a boat lift at 785 Lake Drive, application number V1500004. And Tim, I think you're going to make the...
Are there any ex parte?
Any ex parte? Oh, it's because we are. Are there any ex partes for us on the board?
No.
And staff? Okay, disclosure, okay. Swearing the applicant in?
If you're going to testify, if you would stand and raise your right hand, please. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Okay, Tim.
Well, thank you, Mr. Chairman. The request is a request for a variance from Section 31.05A5. The dock must be located no closer than 15 feet from the side property line. And it's intended, the variance is requested to allow a proposed finger pier and boat lift to encroach over the adjacent side property line, which we are calling the projected riparian property line. The parcel itself is zone R1AA. It's on a .84 acre property. It's currently vacant except for a 100-foot dock and terminal platform that extends out from the upland part of the property to a point beyond the mangrove fringe. The Planning and Development Department records show that the existing dock was approved on April 26 pursuant to a code compliance certification permit. Submitted when the application for revisions to the existing dock were submitted recently by Mr. Edward Riley, who I believe is intending to purchase the property, to add a small finger.
Is he the seller or the purchaser?
No, he's going to purchase the property.
Okay.
I'm not. So we've got a lot of cast of characters here, but I'll try to get this correct. To add a small finger dock and boat lift, the reviewing staff found that the existing dock didn't comply with the location and approved compliance certification. The 100-foot dock is located 40 feet to the east of the approved location within 15 feet of the adjacent property line. The terminal platform is not centered on the dock that was approved in the initial application. I'm going to show you how we normally look at riparian property lines. This is how the staff has historically applied this. I have Mr. Messerschmidt, the assistant city engineer, here if you need to ask any specific questions. Bill's very familiar with this case and other situations. So bear with me. I'm just one staff here walking over here. So this demonstrates, it shows you the existing docks in the area, and you can see in the middle of it is the 100-foot dock extending out into the water. The red lines on there are I call them the projected riparian lines. This is more of there's nothing, you can't go to a plat book and find this. This is what we use when we get in these riparian waters, but it's not, as I point out, the code doesn't really get into these things. To illustrate the application subject property, staff prepared a rough approximation, which I just showed you up there. This shows that the existing dock platform within the projected riparian property lines, but do encroach within 15 feet of the line, I believe, in a couple places.
We're referring to the pier that goes out.
Right.
Okay.
The one to the middle dock, you see that.
Okay.
It's evident if the dock had been built as approved, and I looked at the original, it would have definitely had an adverse impact on the adjacent property owner. Research of county building permit records revealed that the dock and platform had been issued a building permit. A final inspection was completed. And additionally, the staff found a letter from the Rio Mar Bay 2 Property Owner Association granting an easement to build a dock that will infringe minimally on their riparian rights of the association. Therefore, based on these facts that the staff determined, we determined that the dock was vested at this point in time at that location. How it is still non-conforming to meeting the side property lines as applied to the platted side property line and the projected riparian property lines extending over the water. And again, I point out that the real issues are land development regulations refer only to setbacks of side property lines. They don't really go into this situation over water, particularly when we get into situations where we're dealing with this, where we have a partially enclosed water area, we've got irregularly shaped lots, we have a shoreline that's curvy linear, we've got mangroves that extend out there. So it's not something that's easily addressed in at the current time in our land development regulations. When Mr. Riley submitted an application for the expansion of the dock, he did provide a letter which is an Exhibit C in the applicant's application package, indicated the owner of the abutting property to the north, and again, it's the Rio Mar Bay 2 Property Owners Association, had no issue with the proposed location of the dock expansion that encroached over the riparian property line. And I'll show you that. I'll get over there. Although the staff supported the location of the proposed dock extension boat lift, we think that the appropriate location, the planning director, I determined that I didn't have the authority to really do this. We've been doing this in the past. I could have gone ahead and done this, but I was feeling uncomfortable of going forward when we've historically applied it this way, particularly in this kind of situation. So I told the applicant that they really needed to go through a variance request. And I think part of what you're going to realize today, not only the land development regulations kind of open on this, but I think we need to look at them, and that's one of the cases I'll be building as I go through this, as we apply it to this property. And what I'm going to do is I'm going to pull up which will show there the location, the proposed finger dock and that. So just bear with me. I got to get over there to do that. So it's all right. Just bear with me. What happened here? Okay. There we go. What I'm showing you on the screen right now is basically the application submitted by Mr. Riley. And it shows you the existing dock, and then in hash, that's what he's proposing to place out there. Now, in order to grant a variance to the applicants on this, you need to go through certain criteria. 6602 spells out the 7 reasons to deny you can't allow the application, which in these cases we find that none of these are being met. So we're really going into the criteria for determining whether they meet, and they must meet all the criteria. First, then they're all spelled out in 6603. The first requirement is that the application causes a unique hardship. And as we pointed out before, the existing dock was constructed in its current location because the neighbor's dock to the west was permitted, extends over the western boundary of the owner's riparian lot line. And this is from the applicant's response. The application is seeking to obtain a variance for that existing structure and to permit the construction of a finger pier and boat lift. Without the addition of a pier, a lift would not be able to be placed in an existing dock as it would interfere with the westerly neighborhood's use of the dock. And the staff agrees with that. I mean, we can differ on where that riparian line is. As I said, that's really a matter of civil law than rather our trying to do it. But clearly, based on what's been provided, that dock that the the proposed finger pier dock and boat lift needs to be further north of where it is, or it would infringe upon the western property owners' riparian rights. The application is to allow the construction of the finger pier. Such usage of the waterfront property is typical along the Indian River Lagoon for owners of watercraft. And when you have waterfront property, you have some rights to use that property, and everybody else has that. So we see that as something that certainly goes with the property and its enjoyment. As we pointed out, it can't be installed closer to the neighboring existing dock to the west without adversely impacting neighbors' riparian rights and use of dock. So we also point out and look at the findings I just pointed out earlier, that the existing regulations make it difficult for us to apply this. This is not the property owner's fault. It's just the way these things are. So therefore, we find that the application of the existing regulations creates an undue and unique hardship on the property. And then I put a little note there, and this is probably a good note because we were told at the city council meeting to look at docks. So as I said, I think we need to look at a way that we can handle this and not have to go through an expensive and hearing process for applicants coming in, that we could handle in a better way. So when we do some regulations, we'll be coming back before you anyway, so you'll certainly have input on that. The second required finding, that the exceptional and unique hardship is not due solely to the owner's actions. Well, the owners did not have anything to do with these docks when it was placed in there. Clearly, weren't involved with that. The dock to the west does create a problem for the location of the existing dock that prevents the construction of the finger pier and boat lift as requested by the applicant. And again, I said that we have a difficult time because of the encroachment on the projected riparian property line. We can't approve the dock without a variance on that. So we find that there is this exceptional and unique hardship, and it's not due solely to the owners. It's the configuration of where the docks are, the water distances between the irregular shaped lots. It's outside the property owner's control. Third finding is that the variance granted will be compatible with the physical characteristics of the neighborhood. And pointed out by the applicant that if granted, the variance will be compatible with the physical characteristics of the neighborhood. Staff agrees with that. As we point out, for the owner to get its full enjoyment and use of the property, having a boat lift certainly goes with the territory. In fact, the two other properties have boat lifts on them. And the association to the north, the Riamar 2, have no problems with this encroachment in their riparian areas. Therefore, the staff does find this would be compatible with the physical characteristics of the neighborhood. That the variance granted will be in harmony with the intent and purpose of the code, and the applicant's response that it will be in harmony as the owners obtain the consent of the adjacent landowner, the adjacent lot owner of the association. And again, as the staff points out, the requested variance would allow owners of the property access and enjoyment of their docks similar to other waterfront properties along the Indian River Lagoon without adversely impacting neighboring owners of riparian properties in the vicinity of the subject property. And again, pointing out the adjacent property has already given their consent to do this, and that we don't believe the variance will adversely impact any of the property owners' riparian rights. Therefore, we find, if granted, it will be in harmony with the intent and purpose of the code. The fifth required finding is that the variance granted is the minimum necessary to alleviate the exceptional and unique hardship. And the applicant's response that it is the minimum, that no lift could be done without being able to encroach over that riparian projected property line. And again, we point out that that's the only location you really can put that dock and the fingerprint boat lift in order to not adversely impact the adjacent riparian property owner. Therefore, we find that this location is minimum necessary to alleviate the exceptional and unique hardship while protecting the rights of adjacent riparian property owners. In summary, the staff finds that the requested variance will not cause any adverse impacts as listed in Section 66.02, and that the request meets all the criteria of Section 6602. And I probably cited the wrong thing there.
3.
Yes.
You changed
I
it.
did.
to-
166. That should be 6603.
03.
That is not the only formatting thing. And that the request meets all the criteria of 6603 based on the above findings. Therefore, the staff recommends approval of the request to allow encroachment of the proposed fingerprint and boat lift as proposed. And it's a single. There was boat lift was in the application, and I didn't get them all out of here. There's just a single boat lift being involved. I was informed that as proposed in code compliance certification. CC 15-000185, which is attachment C that you have in your package. So unless you have any questions of me, you may want to ask the applicant to come forward.
I do have one question, just to start off with. There's adjacent properties on both sides, and we have a statement from Rearmar Bay 2 giving their approval. What do we have from the owner of the property on the other side?
We have nothing from them unless the applicants receive something. I mean, they're not encroaching on their rights over there. So definitely the Rearmar.
I looked at the overhead, and I really appreciate having that. And a lot of riparian rights have to do with the ability of the boat to maneuver into their
Correct.
dock. And I was just curious was it shallow there? I don't know. I just don't know, what that owner to the west is all about.
Well, all I know is my understanding, and maybe the applicant's attorney can explain it, is that they realized they had to move that dock, had to be moved over, or they would have infringed upon them. And they believe, and they probably had conversations with next door, that that's in a good location. We did not have a problem. And Mr. Messerschmidt's out in the audience. If you would like to ask any, and he's very familiar with it. He's worked with the applicant. Or Mr.
I would
Riley.
like to hear that.
All right.
Yeah.
Bill,
Bill?
were you sworn in?
anything, Bill. It's
I'm not sure of your question.
yeah.
The
Will you state your name,
Oh.
please? And your
Bill Messersmith?
Were you sworn in, Bill?
Yes.
Okay.
adjacent properties, we know from the Rearmar Bay 2 on the, I guess you
East
call
side.
that the east side.
East side.
They're fine with this. What about the owner to the west? It states that consent of the adjacent lot owners. I was just curious where that consent is.
The only one that I know about is the consent of the lot owners to the
Yeah.
north and east, which is the Rearmar Bay Property Owners Association.
Okay.
We don't require consent. I mean, one of the things we're going to look at, I just want to tell you in the code, in these kind of situations, we may require at least they're aware that this is going to be issued and that they would have an opportunity. And that's not in the code. So getting the consent from that property owner, that hasn't been required in the code. Obviously, they're going over their line, so they got a letter, but they're not encroaching on the other property owners. So it's not a requirement of the code to do that.
But boat owners are very generous, allowing, maneuvering their boat. And I wanted to know that they were consent, because
But
it
they were
says the
noticed, right?
consent
But
of
they-
the adjacent
Well,
lot owners, plural. So that's what I was asking.
The property was posted and everything. There's only
They know about
Yeah.
it. And if they have a chance to speak at the public
Right.
section, if they had some comment.
right.
This is the public
I
section.
know, but when we come up with public afterwards, there's a chance for the public to speak. We can-
Yeah. We have not received
Okay.
anything.
I don't know if they're-
Okay.
Okay. I was just, because I had the one, where's the other? I was curious.
Yeah.
Okay, thank you. But the property was posted, and so we know that they're aware.
Thanks
Okay.
for your input, Bill.
Thank you.
Any additional questions of staff?
I don't have any questions at this time.
I have a question,
Go ahead.
please. Why wasn't a request made as for engineering that showed why the existing dock couldn't be adapted for a boat lift? In other words, I see here where we're adding 100-plus feet out into the waterway there.
No, the 100 feet is already there.
That's existing.
That's existing. They're adding to it. And my
Oh,
understanding,
I'm sorry.
Yeah.
I'm in reverse. We're adding 13-plus.
that's to allow the
Okay.
right. And they have to go through DEP and everything. So it's not just like we're the only ones involved with this.
Right. Okay, I appreciate that. It would have been helpful on another point to have had the existing dock to the west as part of this engineering plan, so that we could see.
Oh, I understand. Well, this is their plan that they submitted as part of the code
Right.
compliance. I'm sorry. So typically, you may not show that. So
Right. Thank you.
This gives you a proximity to, of course, one we've already seen, Richard.
So it's clear in my mind, the finger pier, it says on my diagram, it's 30 by 3 foot, so it'd be 30 foot in length by 3 foot wide. Is that correct, Mr. McGarry? The finger pier?
right, there's a 15 by 3, and then another extension out 30 feet. Correct.
All right, now the 15 by 3, the existing wood dock, you're not, the 15 foot by 3 foot is part of, you wouldn't add another 3 foot to the 30 foot because that little piece is already on the existing platform there, correct?
Well,
So it's an additional 30 feet only, or?
no, it's additional going north, and that's north where
Correct.
we're facing. There's an additional 15 feet going north from the existing dock,
Yes.
and then it's 30 feet over to the
From that,
west.
okay, I see where you're coming up with your numbers.
Right.
Coming off, going to the north,
Yeah.
I'm thinking in what I would consider in the front of the dock, but going out from the front would be 30 foot.
So if you notice on his site plan, he does show the existing terminal of the adjacent dock. It's shown in there, which is 25 feet from his platform, existing platform.
Right. The next question, and while we're here on measurements, the platform that's there now, excluding the finger pier, what's the length of that?
I think it's 10 by 12, so it's...
So it's a 10 by 12
Yeah.
platform at the end there. So would it be the 12 foot? Would that be, I guess, from?
I believe it's 12 feet going north from the
12 foot.
edge of it.
Got it.
From the edge, I believe it is. Just, and I'm just eyeballing it.
That's close enough for me. Okay. Questions answered for the time being for me.
Any additional questions?
I know.
Does the applicant wish to make a presentation then? Please come forward. Rebecca, have you been sworn in?
Yes.
Okay. Please state your name for the record.
Good afternoon. My name is Rebecca Emmons. I'm an attorney representing the variance applicant. You've all been given a copy of the application, and we've heard staff recommendations, which we endorse. So I'm just here to answer any questions that you would have of the applicant.
Members have questions for Rebecca?
I have none at this time.
I can answer some of the, if you'd like. I
Sure.
have some insight into some of the questions that were asked earlier of staff. Mr. Riley had contemplated putting the boat lift at the end of the dock where it would be natural that you would think it should go. But I can tell you, because I went out and walked the site, it's much smaller of an area than we're getting a picture of from the aerial. It's actually very tight around there. And the neighbor's boat is a large boat there. And the boat lift comes in this way, but he's an avid fisherman, and from what Ed was told, he'll go out in the morning, come in for the afternoon, and then moor his boat. So he parks adjacent to that property. And so when that boat sticks out, he's more than halfway between the distance of his dock and the 25 feet that's being proposed.
So he's 12 feet in the 25 foot that's shown on the drawing. Is that what
right,
you're saying?
when he moors
Yeah.
his boat.
Okay.
You see that?
So,
And so for
that, if there was a boat lift put there with any size, any substantial size of boat over skiff size, it would impede his use of being able to moor his own boat there, as well as make it difficult to get anything more than really a skiff on that lift at that point. And so that was the reason for extending the finger pier out there to accommodate really the neighbor's use of their existing dock.
Makes sense.
Yeah, and he was identified. Are they I see the way the boat's moored in this one picture right here, and he doesn't have it that direction in this one, but I see what you're saying. When he comes in just for a short period of time, he's going to put it that way.
Mm-hmm.
Is that on a lift? I believe the picture indicates it's already, his boat is on a lift also.
Yes, it's perpendicular to the existing.
Yes.
Yeah.
Okay. Additional questions? Thank you, Rebecca.
I actually have a procedural question, related to the county approving this giving this easement, or the property owners association giving an easement. It was in your backup.
Well, I know.
Yeah.
Well, they gave consent. There wasn't any formal
Yeah.
agreement here.
And so this never came to us when this happened.
No, this was a party between two civil parties.
Yeah.
Parties involved. We're not involved in any of that.
Yeah.
As I said, I believe, and we have attorneys here, they can disagree with me, but a lot of these riparian rights are more into civil matters. It's a little more difficult for us, and we're trying to apply land development regulations to that. That's one reason we need to look at our dock things a little more closely.
Mm-hmm.
Mr. Chairman?
Yes.
I have a question for Mr. McGarry, a couple of questions.
Go ahead.
Thank you. On page 2, the first paragraph, it talks in here, when the staff reviewed, they found the existing dock didn't comply with the location and the approved code compliance certification. The terminal platform is not centered on the dock as approved. My question is this, because if you go down 1, 2, 3, 4th, to the 4th paragraph, it talks about a search was done on the county building permit records and revealed that the dock terminal platform had been issued a building permit and a final inspection was completed. Does that mean everything was taken care of, even though up at the top paragraph that says they weren't in compliance?
Well, it is what it is, meaning that and I point out, the dock could never, it may have been given a code compliance certification, but it could never have been really, it would have infringed on the next door neighbor. It was a kind of a, shall I say, sloppy job by the reviewer. And Bill, Bill, you didn't have anything to do with that one.
I did.
Oh, okay. Well, I didn't mean to bring up the.
I'm going to have to be brief because I've got an engagement at 2 o'clock that I got to get to. But the dock builder came to me after he went out and examined the site and said, this dock that I've got permitted this way is not going to work. What can I do? And I said, well, we're kind of stuck unless you can get permission from the adjacent property owner to move closer to his property line, which he did. And I said, well, that's fine. Go ahead and build it there. So if that's wrong, that's all on me. And then I did not update the record after he did that. So that's where he built the dock. And when he got all done, it was approved and finalized.
So what Bill's pointing out to you, generally it would have had to come back to revise the thing. So that's a technical thing. I apologize, Bill. I didn't mean to throw you under the bus here.
No problem.
So when the dock was built,
Yeah.
it met the plans. That's why the building department signed off on it.
Yes.
Yeah.
It met the plans that I had approved.
That you had approved.
Right.
And they're not going to run around with a tape measure measuring where
They're
a
not
dock
going to run around
goes.
with a tape measure, and I didn't go back through planning, which is what I should have done.
Okay.
It's tough to get a point out in the water anyhow.
And I should have had that in the record, so I apologize.
My other question is, the dock that's there now, how come they didn't put a boat lift at the end when they were finished? What was it? Was it just a purpose for a walking dock?
Why don't you have a three-car garage on your property?
Excuse me?
Why don't you have a three-car garage on your property? I mean, they didn't want one at that time.
Actually, you could have just answered it that way.
Okay.
I was curious. Why.
I'm sorry.
Yeah, the three-car garage with me has nothing to do with this particular
You're
hearing.
correct. I'm
My
sorry.
question was, what was the reason?
I
And
guess
you
they didn't
answered
want
that.
one. I don't know the reason.
Okay, thank you very much.
Okay. Any other questions for me?
No, thank you.
Thank you, Bill.
Hey, thanks, Bill.
Okey-doke.
We now, if is there any additional questions, either the applicant or the staff? Then we're going to open it up for public. Is there anybody here today that would like to speak on this matter? If so, it's your time to come forward and speak. Seeing nobody coming forward, I'm going to close the public part of the meeting. Closing statements by applicant. Anything additional? You weren't sworn in, though, Bill.
I am about to be.
Okay. I was watching you. You know that.
Well, I do promise to tell the truth, so help me God.
Well, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Absolutely,
Thank
I
you.
do. To answer your question, this dock was built by a prior owner who had absolutely no intention of doing anything with that property other than selling the lot. So they didn't put any extra furnishings on the dock, not to mention a lift. When the Cyrus's bought the lot, they weren't quite sure what they wanted to do with it either, so they just left the dock as in the position that it was when they found it. I appreciate Mr. Messerschmidt. He's gone explanation about what happened to the dock and why it got that way, because I was trying to figure that out myself. And I think we concluded that it was just a field, we thought it was a field adjustment on the part of the dock builder, because there was no way with that other dock, which had moved actually over the Cyrus's riparian lot line, extended, to make it ever work the way it was designed. So it was a field change, and apparently approved in the informal way it was done. So,
Bill, also in the application you submitted, you made that comment in there, exactly what happened there. It was in there that the prior owner actually did that, not the present owner, because I read that.
So,
earlier.
I mean, this is about, these adjustments that you make in these narrow channels that come in. Typically, I had another case very much like this, and what the surveyors will do, those who are knowledgeable, they go out to the deep water and they measure across there. And then they allocate the space to each lot that's in the cul-de-sac, so to speak, based upon your water frontage. And then they draw the lines up to there, which would have made these lines go that way on the Cyrus's lot. But you're right. It's not in any code. It's not in the county code. It's not in the city code. And they just do the best they can to make it work for everybody. Thank you.
And this is from Mr. McGarry. The property owner that we did not hear from, the property was posted, but no letters were sent out, correct?
No, I don't believe we send letters.
Because it's not required in our code to do that. Is that correct on variances?
I don't think so, but I don't know.
Our client dropped off a postage.
Oh, okay, then they are. And I apologize. I don't handle that sometimes. So.
Yeah, there was a $350.
Okay, it was 500 feet then, if we did. Okay, so they were sent out.
Were sent out from the city.
I apologize. Yes.
I mean, we paid for the postage. I'm assuming it got done.
They paid for it. That's handled by my administration. Usually, if you post it, you're sending notices out. Should have.
My one other question I have, from the edge of the current existing dock, you'll go 30 foot past that, correct? Be 30 more feet, which would be past the picture that I hear on Exhibit B.
You mean going to the west? Right.
Going to the west, where the boat, it's on my left because I'm looking at the overhead. So that little pier situation will go out 30 more foot, and that's what you say is going to give the fellow room to put his boat.
Right. Well, it gives him room by moving the finger pier, adding the 15 feet north, then 30 west, and that gives you the room in there. You couldn't just probably move it across without going further
You
north.
have to go out.
Yes.
Out from the existing.
On the overhead with the yellow line that kind of circles the water body, is that identifying the natural mangrove there?
The yellow lines are the property appraiser.
Property line.
They're the property lines generally.
Okay,
Remember,
but,
this is a GIS, so they're approximate.
Okay, but the one that circles the body of water right there.
This one right here?
Yeah.
Those are property lines.
Just
See, they
connecting
own it
property
there,
lines.
connecting.
Okay. So the other are considered submerged lands or mangroves?
Well, there's submerged lands beyond that, yes.
When the 30 foot goes out, do they have to check to see if they're over anything environmentally sensitive? Do they have all
They
the
have
permits?
to get a DEP permit.
So
they're
that's coming.
Yes.
And that's up to DEP. Okay.
Again, that question came up during our council meeting. So, as I said, when we look at the dock code, we're going to be looking specifically at what DEP or the Corps requires on that to make sure we're covering ourselves.
Yeah.
So DEP, when they look at it,
They require the gaps between in the dock, planks and all that.
But if it's too close, in their opinion, to something, they could
get into
deny?
that. They get into the mangroves and all those aspects of it. Yes.
So they could have them scale back the project.
No, I believe they're okay. The DEP is fine.
DEP
on this.
is okay with this. Yeah. Was that part of this? Because I just got this the other day.
Yes.
Okay.
Normally, we whether we approve or deny, we can't use the DEP. We can't hold somebody up because they don't have DEP approval.
Understood.
They're under the state passed a
they have
statute that doesn't allow us to do that. So basically, they can't start construction unless they have their DEP approval.
They have to get that permit in addition to.
That's correct, in addition to ours, before they can start.
Understood.
Any additional discussion? We're opening up now for our discussion. If there's no discussion, I'm looking for a recommendation.
Move that we accept staff's recommendation for this variance.
I have a motion that we accept the staff recommendation. Do I have a second?
I'll second.
I have a first and a second. Any additional discussion? Seeing none, we'll call for a vote.
Mr. Dagg?
Yes.
Mr. Cahoy?
Yes.
Ms. Polinsky?
Yes.
Mrs. Manous?
Yes.
Mr. Laufer?
Yes.
Passes 5-0.
Thank you. Have a good day.
Tim, when we work on the codes for docks,
Yes.
This really was a very straightforward case for you. Were you pretty much?
That's what I'm saying. I don't think we should be doing variances where we can handle it because it's expensive, it delays.
$540.
And in this
for
case, I think the gentleman's got
application. Yeah.
Yes, and they bring in attorneys in. So
Yeah.
where we can, as long as we have some criteria and guidelines for the staff to be able to apply the code, we don't need to be going through public hearings. I mean, that's what we do for our
Right.
job and paid to
Right.
do.
Yeah.
And the only reason I came before you, it was an area to me. It was a gray area. I didn't feel comfortable just going ahead and do it. But in one way, this is a case, to show that we need to really look at doing some changes in the code so we can just handle this. And then,
Right, and then with that easement being granted, it just seems to me it should have been a little bit more
well,
solid
it isn't.
into-
There's no. See, one, the riparian property rights is not. It's not like a property line, and even in our code, and this is it. And I pointed out to the applicant, even in our code, let's say you put the dock, there's the property line, you put the dock 10 feet from it, and the next door property owner says that's okay. Our code doesn't allow property owners to do variances among themselves. See, I mean, I'm not saying that you couldn't put provisions in there to allow somebody closer if agreed to by the property owner, but our code doesn't have that. So people can't just willy-nilly make changes to the code just because a bunch of property owners get together and say, hey, we're going to change the code and do
But
whatever.
someday someone's going to sell a piece of property.
Yes.
It's like, I didn't want this.
So that's why I said, hey, we don't have a problem with this, but you need to go through the variance procedure.
I don't have a problem with your conversation on the variances. Going forward, I was at the meeting too when they talked about docks.
Yes.
And definitely going to have to take a look at the situation because we're under the growth situation again. More people want to build docks. They're going to want to protrude more out into the lagoon, and we need to take a look at that. I would think anything that's done moving forward for variances, where the P&Z director would take a look at the situation, that the points that he's allowed to approve are very clear. Then if there's any gray areas, it does come back before P&Z, so it's heard.
Oh, we would do it that way. I mean, I would be uncomfortable to have too much broad discretion. That leads to problems. A panic attack on the part of your planning director, and you don't really have that. I'm an old guy,
It was rough on you the other night, but anyway, we're trying to make it very easy for you. But as long as when people come in, it's clear.
Yes.
Then if there's a gray area, it comes back, it's out in the open. Then going forward, again, since we're under the growth situation again, people won't get irritated down the road. And you're absolutely right. Property owners can't get together and say, hey, let's move it over here a little bit. We already heard today the dock was kind of in the wrong place, which really wasn't the owner's fault that contracted with the individual that built the dock. And they got the sign off. Everything was okie dokie. It was picked up now when somebody is getting ready to buy the property.
Good points.
I have a little different perspective on it. I think some of the regulations we have, I think there should be more discretion by our planning director. And some of these, this is overly burdensome for the individual. There's no major conflicts here in some cases, and I think discretion is somewhat stops big government from always having other people oversee my property and etc. that I want to do in my lot. I think we go too far sometimes, and I think there's a balance. Without the balance, one or the other side is overbearing, and you can be in a community where there's no regulations and you have things that are inappropriate, and we've seen some of that in our city. On the other hand, we've seen things in our city now where we are overbearing in some ways. We're putting people through all kinds of things they shouldn't have to go through, in my opinion, to be able to enjoy their property. So it's a balance, and until we keep the balance, I think it has to be there. And without the balance, I think that's not good government.
And I think that's what part of your job when I bring these regular draft before you to look at that balancing act. I agree to you to that. But as your planning director, anything we need to have some criteria that allows.
Yes, this one I think you did the right thing on. I think there was enough gray area that we should see it, speak to it. But that cost that individual homeowner
and that's why I felt that.
There's
yes,
$1,500 at least there.
Yes, no, I totally agree with you. You shouldn't have to go through a variance procedure where it's not really totally necessary. But there should be the code should take care of that, or give the administrative authority enough room to be able to handle that and to work with, if the property owners are being affected, to come out with a satisfactory resolution.
Well, it should be very clear. And when there's areas of uncertainty, that's where it comes to the P&Z board. As I consider P&Z board a buffer, so the stuff gets out in the open. The other thing too, we want to be really mindful is the other property owners involved. The notices were sent out. No one stepped up, but it gave people a chance, if they did have a concern with this situation, to stop by. Again, we're under the development situation here in the city. We need to be mindful of other people's property rights and how commercial development or this type of dock building, et cetera, will take place. How will it have an effect on your property or your neighborhood?
Yeah, the only thing that was brought up, I thought was a point we may want to look at, City Council, was that we may want to, where we have these kind of situations, is to give the adjacent property owner, the reason they were notified, but if there hadn't been a variance,
they wouldn't have been.
Yeah, and then the question comes up, do I have to appeal it? Well, I think most disagreements could be handled in my office before, with the parties, without having to go to any appeal.
Even a letter to both homeowners on both sides.
And that's what I was thinking that we
There's only three people are involved here.
Right.
The three adjacent property,
and
two adjacent property owners.
I think what we may do is having a 10-day period where they have an opportunity to, and that's what we're going to look at. So that would take care of this.
As an alternative to this board.
Yeah, to have to go to appeals, I really do not. Some of these we've been through.
But it was interesting in this site plan because there's another dock on the south side, north side?
Yes.
With a rather large boat there.
Right.
And did he have a right for any kind of input here? So
that's why he had to move over, because his boat, when he sits it in here, is too close for him to maneuver in there.
I'm talking about this one.
That one.
Yeah, that one too.
Yeah.
I have a question. Why did they have to have an attorney? Why couldn't Mr. Riley take care of this on his own?
Well, I believe they're not here. I believe Mr. Riley has a contract for the property. Okay, so part of it is they're part of the team. They're selling the property. So this is one of the things he wanted to have to make sure he had. Yes. Okay. So I didn't want to get into all that, but that's, I think, and most people when they're doing this thing, there's money involved, and it's important that he wanted to the dock and everything.
That it was going to be possible.
It would be a monetary situation for him to say,
variances can be complicated.
Oh, yes.
Right. Okay. Technical part of it.
The technical can be. Some are simple.
Well, the variances too, as you know, a lot of that have been here for quite a while. When we had I think we had a variance board, a lot of variances were put in place that really irritated a lot of people, and that's how a lot of things got built. So actually, a situation like this, where it's out in the open, there was a little bit of a gray area, but now if you have any of the surrounding owners come in and say, hey, we didn't know, the letters was sent out, it was done out in the open, there was good discussion where this person could have their finger pierced. So it wasn't easy to get the variance. In times past, the variances weren't that hard to get when you want to, increase your building on your property, go too close to the other guy. So it did irritate a lot of people throughout the city.
I think that the big difference is if, as Ms. Lyon will point out, that following the rule of law that deals with variances, I don't think we saw a lot of that when the Board of Adjustment was doing these.
Yeah, so, I don't want to get into that.
You're a different body. You're very familiar with due process and the quasi-judicial system. I think we have a good system here.
And we've actually had very few variances since it shifted over to us. I think we've done maybe 4, 5.
Yeah.
Not many.
Not many. I mean, I do, so you're aware, I do some administrative variances, but these are these little minor things where people...
6 inches of the line.
Yeah. So that does occur.
And the code allows that.
Yes, it does.
Would the previous dock exception have been treated as a administrative variance?
Well, I didn't look closely at it. I think it was close enough. It'd been okay without a variance. I didn't get into that on that dock. There's one of these. That was an old dock that I don't even have records of. When it was approved. To be honest with you.
Are there any other planning department matters?
No. All I want to point out, we got a full slate coming. We got 4 items up before you at the next meeting. So please don't go on vacation.
July.
What date is that, Tim?
July 2nd? Isn't that what it is?
2nd?
We're going to meet July 2nd? Good. Okay.
I believe it's July 2nd.
Is that the next
First
meeting?
Thursday?
That's right, because we're off Friday the 3rd, so
Yeah.
it would be the 2nd. Okay.
Clarify that
Friday
with
the
me.
3rd?
We're going to make vacation worthwhile, huh?
Yeah, July 2nd.
They won't be. I don't think they're that.
The next
anything
meeting is
difficult.
July 2nd. Is that what I heard?
Yes.
Okay.
Uh-huh. And one of them is going to be the alcohol beverages. I explained, we're running the ad on that.
Back to where we were today about this particular, is there revisions coming to us to talk about some modification to the code as far as these docks and things like that? Is that in the works, and is that way down the road, or is there nothing been
Well,
planned?
no, I've kind of got the order to start working on it. So I'm right now gathering some other ordinances in other jurisdictions and take a look at it, and we'll be coming back to you. Probably do a workshop like we've done.
We're going to tie several of those together? Or
Yes. No, I wanted to tie.
Individually done. Is that
I wanted to clean up that whole dock section. I can tell you there's already a proposal in, and it's a legislative item, so you know that. We've had a problem, Royal Palm Point. Basically, we have people leasing docks out, running marinas where they're not supposed to. I've got a person, already a property owner, under a compliance agreement, and one of the things they're going to do, and I don't really have a problem with it, it'll be up to you all to make a recommendation to council on it, is to allow with certain limitations people do. It's so hard for us to enforce. I mean, it is impossible to really enforce. So we don't want to create artificial marinas, but at the same time, understand property owners in a commercial, and this will be only a commercial area, got docks there. If they want to lease it out, we would take care of the parking issues and all that as part of the approval and the docks. But everything's underground right now, and we have to send code enforcement out. It's just an ongoing nightmare, and I think we just got to fess up to it. I don't see any harm in it to do it that way.
Tim, I was one of the city that near Virginia Beach, and they had some of the same kind of issue came up. You want to know how they got around some of the stuff? There's one of how smart the consumer is out there. They temporarily leased the 1% of the boat to the owner of the property.
Oh!
Now he's an owner in the boat for a period of time.
You're right,
and then there's you don't regulate because it's the
Mr.
gentleman's
Chairman,
home.
You should not have brought that up. Now
I'm telling you, it's already out there. It's already out there, people. You find a rule, they can find a way around it. Okay, and that's what they did.
If you read the letter of the law, it says a tenant. So if the person's in that and they have part ownership, you're right.
I'm telling you,
that's the way around.
It surprised me because we were involved only because it doesn't matter.
I mean, I think this is a case where it just doesn't make a lot of sense anyway. That we can control. The thing we don't want is people setting up marinas, which you get into a lot more. That you need to have the proper zoning. So okay, that's a good story. I might use that when I bring my staff report forward.
Are there any board member matters today?
I'm curious, as you're developing information on the Stormwater Authority, will that kind of information, will we be working on that at all here at P&Z?
Not that I know of. I haven't been working on it, but I certainly, if you would like to have an update on it, I could have Monty discuss that.
Yeah, I was just curious about stormwater retention, on development.
Well, one thing that we have to do is to put some more emphasis in our stormwater, to put in filtration beds and all that from water bodies. We haven't done it, and the reason we haven't done it, it's in the comp plan. If you have one night you're not doing anything and want to fall asleep.
One night.
But basically, we haven't done it because I was trying to do all the wetlands at one time. I think there might be ways that we could just do some incremental changes in there and put some provisions in there. The thing is, we're already a developed. It's very difficult to retrofit.
Well, that's
to come back in there. But I think we need to make a start somewhere along the line. So we will look at some of that if that's what you're talking about. We're okay.
I'm not sure what you were talking about. I want to go.
Well, if you're from Virginia, you remember the Chesapeake Bay program? Well, it's the idea about putting in vegetative filtration, swales to prevent direct. That's basically what we're talking about. I mean, we now have some provisions that swales stuff, but we're also, I think, another important thing, and some of it is water quality oriented. We need to do a little more of that, where we have the sheet runoff action that we can require that be put in where we can.
But we don't have that in code at all.
We have sort of provisions
to do. It's mostly retention right now, isn't it?
Yeah, it's retention, and you can't allow water to directly go off into any water body.
Right.
So we get in the Keys. We got into that. I mean, you wouldn't. Your grain gutters all had to come back, and we did a lot of. So there's some things we try to do that, or the public works people try to do that. I think we could do a little better job in the code. It's one of those things. Instead of trying to do the whole enchilada, which I was trying to do, and I kept putting off. I think we could take a look at that. It certainly would be helpful. In fact, I had one of the individuals who in lagoon preservation and cleanup was in my office, asked me why I haven't done that. So I did feel guilty, but I said, gee, only so much you can do at one time. But I think we should start looking at that. Yeah.
Other members?
You got your work cut out for you.
He always has.
That's good.
Hey, but I have you people. I want to tell you.
So it will come to us, won't it?
If there's no other business. Here she goes.
Yeah, no, you mentioned that we had another station in the works. Is that coming before us?
I haven't gotten the application. I did get a call, so they may be working on it. I believe they're going to come forward.
And that was west of town?
That was on 43rd, and so it's like where the Szechuan Palace is in that area.
Right. Okay.
Wasn't that on the list?
Okay, that's for me.
All right.
Thank you.
Anybody else? If there's no other matters to come before us, we are adjourned.
Thank you all.